welcome to Legalese on Me. I'm your host, Malia. Legalese on Me is the show where we make the complicated legal stuff simple and easy to understand. Today, we're going to be talking about copyrights. In fact, we're going to be talking about clearing up the confusion about copyrights. Everybody wants to create, wants to make creative works, and sometimes we get hung up on whether or not we need a copyright, a trademark, a patent. What's the difference? So today we're going to talk about it. So, by definition, copyrights can be, again, confusing, but they are a form of legal protection for creators of original works. That gets dicey for people because what is an original work? Think books, music, movies, photographs, and more that are from your personal brain trust. Not things that you're borrowing from other people and regurgitating, but things that you have actually creatively come up with. The purpose of a copyright or copyright law is to encourage creativity and innovation. So, by definition, you need to be creative in order to earn your right to exclusive ownership of a work. That exclusive right to reproduce, distribute, and publicly perform your work becomes yours at the time of creation. Another big misunderstanding about copyrights, with most people believing that the only way that you can get a copyright is to formally register that copyright with the US Copyright Office. Not true. Not true. But it does get tricky because, again, most people don't really know the difference between other forms of intellectual property, copyrights, patents, and trademarks. What do they cover? How are they similar? How are they different? We're going to clarify. A trademark, listen carefully, listen carefully. A trademark protects brand names, logos, slogans, things that ensure consumers know the difference between brands in the market, between businesses that are bringing products and services to the market. A patent, on the other hand, protects new inventions or innovations like gadgets or new technology. All right, so are we clear? Now that we've got that cleared up, let's talk about the process of registering your copyright. So I'm going to go back because we've talked about patents, we've talked about trademarks. I want to just repeat definition of what falls under a copyright before we talk about how to register your copyright. Photographs, movies, music, books, those types of original works. Now, I did skip something that's very important to most of my listening audience since I am the social media lawyer. What about your social media content? Yes, your social media content falls under copyright law, not trademarks, not patents, copyright law. So, yes, some of your social media posts, not all, it would depend on what the post is, how original it is to you. Um, but those posts, just like other videos, just like other written works, may very well qualify to be registered um, or may have automatic copyright um, protections attached to them at the time of creation. So, the process of registering a copyright. Now, again, you have a copyright as the creator, as the brain trust of the creative work immediately. As soon as it's created, you own it. If you didn't do anything else, you would have some level of protection for your work. If you wanted to go a step further and enhance those protections, you would have to register your copyright with the US Copyright Office. So, this is talk little bit about how you do that. Well, one, maybe I should back up and talk about some of the benefits to doing that because I think that's a big question that people have. Why would I do that if you're telling me I get protections the moment that my work is created? Why would I bother to go the next step to register the mark? And the answer to that is, which I've already kind of alluded to, there are enhanced protections that you get with when you do register your copyright with the U.S. Copyright Office. For example, you're creating a public record of your ownership of the copyright, meaning if you create the work and that copyright attaches automatically and you do nothing else, you know it. You know when you created that work. You know that you are the original author or creator of that work, but no one else really does until it's challenged and then you prove it out. But sometimes that can be a process. So registering your mark with the US copyright, that sort of puts everyone on notice that you are in fact the owner of your mark. And so that in and of itself is a huge benefit if you ever want to bring lawsuit for copyright infringement. Now, I want to be clear about this because this is also a huge confusion for folks. The law requires that you have registered your copyright to bring a federal lawsuit for copyright infringement. That does not mean that you are without remedy if someone violates your copyright and you have not registered. What do I mean by that? There are steps that you can take to protect your copyright even if you have not registered it. For example, there are simple cease and desist or DCMA takedown letters that you can send to internet service providers. For example, if a website is posting your content, even if it's a third party posting your content on a website, the Copyright Office, the law has created this process whereby you can send a letter, and it's very, very technical in terms of what has to be in the letter, but essentially stating your ownership of the copyrighted material, being clear about what the infringement is on your ownership, and requesting that that material be taken down from the website. And this is specific to digital works. And so, following out that process and becoming very familiar with that process is very important. That is a pathway for folks who have not registered their copyright. You don't have to demonstrate that you have filed anything with the US Copyright Office in order to do that. A simple cease and desist. So, take out that more formal process and that nomenclature that I just mentioned, and the good old fashioned cease and desist. You are infringing upon my copyright. I am the original owner of this work. I have not given you a license or permission to use my work. And I would like you to stop violating my copyright. All of those things are available to folks who have not registered their copyright and, can be very effective. Um, However, sometimes they're not. And in cases where you take those steps and you are not successful, the only other option that you might have is a lawsuit. And again, in the United States, the only way to file a federal action for copyright infringement is if you have actually registered your copyright with the Copyright Office. So, how do you do that? It's actually not that complicated. You want to head over to the US Copyright Office, their official website, and find the form that matches your case, fill that out, submit it along with a copy of your work and the required fee. And of course, I am oversimplifying this because I did not say it in the beginning, but I'll say it now. I am a lawyer. I am not your lawyer. If you need a lawyer, hire a lawyer. This is not legal advice. This information is for educational purposes only, nor is it meant to be an exhaustive overview of every single step that you were to take, but it's just to sort of give you enough information to set you on a path of exploration so that you can be empowered to do what you need to do for your business and brand. But it's really not that complicated. I've had questions in the comment section on some of my social media feeds about the fees compared to some of the other intellectual property protections. Copywriting is less expensive than some of the other trademarking or, of course, getting something, a product patented. So I think $45 to $65 for a basic copyright filing is usually what you're looking at. It can be more complex than that, but for the most part, that is the fee range. So it's not that expensive. And I understand for some people that is a lot, especially if you're talking about copywriting multiple things. But I want to say this also: you should have a strategy to the decisions around what you're copywriting and what you're not copywriting. I would never suggest that everything that you create, you should seek a copyright, because some things probably just really are not um, going to pass muster with the Copyright Office. For example, especially when we talk about social media posts, um, originality is one of the requirements for qualifying for copyright protection. And that's one of the things that the US Copyright Office looks at when deciding whether or not to grant exclusive rights to reproduce, distribute, display, and create derivative works from the material that you're seeking to have copyrighted. And the things that they're looking at around originality are we talking about facts and ideas or theories? If so, those typically are not able to be copyrighted, right? Because those are considered in the public domain and available for anyone to use. So if you're simply regurgitating facts and theories and ideas that you've picked up from someone else or somewhere else, and you've put that in a social media post, yeah, as a part of your strategy, that would be sort of low priority, understanding that that's a lot less likely to be um, copyrighted, or at least registered with the Copyright Office. Also, common knowledge, information that's widely known or discoverable. Again, we're getting to the creative authorship. How are we demonstrating that this is something that is unique to you, to your brain trust, to your creativity, versus you just took the time to take information that is widely available to everyone and put that in a post? The shorter your post is, the harder it's going to be able to be for you to prove creativity and originality, right? Because the more that you give, the more that the Copyright Office can look at to see, okay, this is a different perspective, this is a different viewpoint, this is something that's not widely available or widely known, and we can assign creative authorship to this work. And all of those derivative rights and so on and so forth can be attributed to this work. Government works, again, in some jurisdictions like the US, works created by the government or its employees generally are not protected by copyright. And then simple designs and layouts, basic shapes and patterns, and that sort of thing that lack creativity. So you should always be asking yourself, is the thing that I'm seeking to have registered, or I'm seeking to enforce protections with respect to a copyright, are they clearly original and creative and unique to me and my work and my authorship and my design? So those are the things that I want you to be thinking about. Now, I want to move on to infringement. I'm just going to check these comments real quick to see if anybody has dropped any more specific questions. Nope, not seeing anything. Let's move on to infringement, especially in the context of social media, because it gets really, really, really fun, because we have so many. brands, and just other creators that love to pick up a creator's work and use it. And where it gets really dicey is when that use is for commercial purposes. For example, you have a creator who has made a post and a brand likes it because maybe their brand is included somewhere in that post, maybe inadvertently or purposefully, but they are not the subject of that post, nor has there been any deal worked out with the creator. The brand sees it, they like it, so they grab it and they upload it as an original post. Um, is that copyright infringement? Maybe, maybe. It is likely that if there has been no license by the creator to the brand to use the post, again, that they've created, whether or not it includes a shot of, maybe a brand logo or a mention of a brand, it's still that creator's original work. And that brand should be seeking a license and paying for the use of that creator's post. Um, there have been cases where there have been challenges about whether or not that post, by simply publishing it on a public platform, if it is in the public domain. And I think by and large, the answer to that is no, it is not considered in the public domain for the purposes of determining fair use. That a creator maintains copyright protection for their social media content. Now, what is fair use? It's a legal doctrine. So, again, our job is to make complicated legal stuff easy to understand. So, what you need to know is it allows the limited use of copyrighted material without the permission of the original creator under limited circumstances. And what courts use to determine whether or not something falls within fair use, really four simple factors. One, the purpose and character of the use. They're going to look at whether or not the use is for educational purposes or commercial purposes. So, that example that I just gave you, where a brand is literally taking someone's social media post and using it for an ad, a commercial purpose, probably not going to be fair use, even if it is considered in the public domain because it's for commercial purposes. Now, if another creator uses it to further educate on the content of the original creator, maybe fair use. Also, something to consider is the terms and conditions of the social media platforms. Every social media platform that you post on has T's and C's. You need to go and read those, and it's going to have some language around not only what the platform can do. So think of your big players: TikTok, Facebook, Instagram, YouTube, LinkedIn, about what they can do with the content that you post. And all of their terms of use are different, but they're also going to talk about their right to sublicense your content to third parties. And then they're going to talk about what other creators can do with the content that you post on their platforms. They're going to usually have a separate copyright policy. Read those, become familiar with those. It might drive your decisions to post certain things on certain platforms or not to post certain things on certain platforms. But be informed about what those parameters are before you just start posting your content. Now, the second factor of fair use is the nature of the copyrighted work. What are we talking about? Again, are we talking about a social media post? Are we talking about a legal periodical or a medical periodical that is meant to provide educational value that may be then used, an excerpt of that is used to further educate a community of people? Um, Also, something that's considered the amount and substantiality of the portion of use. How much of the work is being used? If you take the entirety of someone else's work and you regurgitate it, maybe that's not acceptable. If you take a quote from it, if you take a paragraph from it, if you take a chapter from it, depending on the situation, that's more palatable. maybe that is okay in the given context. And then fourth, the effect of the use on the potential market for the copyrighted work. Again, all of these areas of IP really go to protecting the value of the work and determining how that value is calculated in the market. So if the use of that work by a third party substantially diminishes the value of that work to the original copyright owner, we probably have a problem. And that's something that is going to be considered when we talk about whether or not fair use is at play. I know everybody likes to say, well, it's fair use, it's in the public domain. But those are really the four factors that are used to determine whether or not fair use is, no pun intended, fair. So let's wrap up this episode and recap. Register your copyright to maximize your protections. Understand the difference between a copyright, a trademark, and a patent. They are all pillars of intellectual property and rights that creators have, but they are not the same. They are very different and apply to different forms of work, products, and your business, and have different values because of that. And if you are a business owner, if you're a content creator, you need to be comfortable at the most basic level with what these differences are, especially if you're a product-based business, if you're a service-based business, if you're a business that is deriving a lot of your customers or clients from social media, you need to know the difference. Know what can be copyrighted, what can't be copyrighted. Keep an eye on fair use and that doctrine, and understand when it applies and when it doesn't apply. Because not only are we talking about you protecting your work and your copyright and your interest, but making sure you're not an infringer, right? When you pick up somebody else's work and you like it and you want to use part of it, you should be thinking about fair use. You should be thinking about those four factors that I gave you that are used to consider whether or not fair use is in play before you use someone else's material. I hope this episode has helped you demystify the mystery around copyrights. And remember, knowledge is power. And don't hesitate to do more research on your own. Explore resources like the website, the U.S. Copyright Office's website. They have a ton of informational material there that you can go, FAQs and videos that will educate you on what your rights are and steps that you can take to protect your creative work, your creative works, because all of us will have multiple creative works because of why? We're creators. But thank you for tuning in to Legalese on Me. Join us next time where we're going to be tackling the reassessment of your business's organizational strategy. Everybody likes to choose LLCs, but is that really the right business structure for your business? Let's talk about it. Stay creative, stay informed, and stay legally protected. See you next time.
Talking all things legally, legalese on me. For entrepreneurs and content creators, legalese on me. Talking all things legally.